when the court date is. Another way that the court is reaching out to people is if they have their email address. They'll be reaching out by email or by phone to let you know when the future court dates are. So just a little bit about illegal lockouts. If you are locked out from your apartment, please call 911 first, and the police will be able to let you back into your apartment if you can show that this is actually your apartment. Also, they can reach out to the landlord or the super to ensure that you get back into your apartment. If the landlord or super does not allow you to get back in, then you can reach out to us, or you can file an order to show cause to get restored to your apartment. HP proceedings. We're actually doing emergency HP proceedings, and that is just for emergency repairs. So for example, there's no gas, there's no hot water, there is a giant leak or hole or rat infestation or anything qualifying as a C violation or worse, we can actually file an emergency application to get repairs done in your apartment. So I'm going to turn it over to Sam, who's actually going to be talking about the eviction moratorium.
Hi, everyone. Hopefully you can hear me. My name is Sam Corman. I'm a staff attorney with Brooklyn A. Thank you all so much for being here. So the first thing that I'd like to go over with you is basically the way that non-payment cases work in housing court, because with the times that we're in, there's a chance that folks might have to go to housing court for the first time, and it can be scary. So we want to make sure people know what to expect. So this flow chart lays out the basic way that housing cases work. You can see it there for yourself, but to give you a basic outline, the first thing that happens is that if you are behind on rent, usually by a couple months, the landlord can send a 14-day notice, a 14-day demand for rent. And that's just to put the tenants on notice that they owe rent. The next step is the landlord's attorney will draft a notice of petition and petition. And that just means those are the legal papers that are used to start a case in court after the landlord goes and buys the next number. And both the 14-day notice and the notice of petition and petition need to be served to you or served to a tenant in a very specific way. And if you ever receive these legal papers, you should try to speak to an attorney about the way you got the papers. So the next step is the legal papers will let the tenant know that they need to come to the housing court to answer in the case. An answer means the tenant's response to the non-payment case and the defenses that the tenant wants to present to the court. So within a certain amount of time, the tenant comes to the court and answers, and the case is set down for its first date. Now, if a tenant doesn't appear, that's called a default, and that can result in a judgment automatically going to the landlord. If the case proceeds after the answer is filed, there can be a negotiation with the landlord's attorney. Tenants can reach stipulations of settlement, which is, it's a legal document that where the parties agree, that certain things are true, that, a certain amount of money is owed, and the tenant agrees to pay that within a certain amount of time. If there's disagreement about the amount owed, or if there are defenses that need to be litigated and argued about in the case, there can be motion practice in the case. The tenant or their attorney can put in motions to try to dismiss the case or reduce the amount that the landlord is trying to get, and those motions will be decided. And if a case doesn't eventually settle, then it can go to trial. And trials happen a lot more quickly than in other courts, and they happen, in front of a judge of the housing court, and then the judge will decide one way or another who's the victor in the trial. If a landlord is successful in getting a judgment against a tenant, either because a tenant missed their stipulation of settlement pay dates, or if a tenant loses their trial, the landlord can get a judgment, which means they can get possession of the apartment. And that's the basic outline of a non-payment case and what to expect. But of course, if you ever receive legal papers, we would encourage you to contact Brooklyn A. Next slide. So what is this eviction moratorium thing? Hopefully folks know. Just to give you some general information about eviction proceedings and what's going on with them right now. Right now, eviction cases and pending eviction orders, so if there was a case prior and a landlord got a judgment against a tenant, those are all suspended for right now. So the eviction proceedings aren't proceeding forward, but that doesn't mean that tenants are not currently under an obligation to pay rent, that is. So to give you some information about the eviction moratoriums that have gone into place. So you might know that Governor Cuomo signed an executive order in around March 20th, and set up an eviction moratorium that prevented the initiation of eviction cases and evictions in New York for all tenants and occupants, which lasted through June 20th, 2020. So we're coming up towards the end of that first moratorium. There was an extension made to the moratorium, which put some certain limits on it and made it so it doesn't cover quite everyone, but extended it to August 20th, 2020 for those people that are covered. Next. So what are those limits that we're talking about? So the extension that would go until August 20th, 2020 said that there shall be no initiation of a proceeding to evict for non-payment against someone that is eligible for unemployment insurance or benefits under state or federal law, or otherwise facing financial hardship due to the COVID-19 pandemic. So that sort of narrowed the group of people that are covered by the moratorium. But everyone who, is just eligible to get unemployment or is facing some kind of a financial hardship due to the pandemic, they would be covered and couldn't be evicted or have a case started against them until the 20th of August. So initially, it seemed that the language put the burden, like put the initiative on tenants to have to show these things. But in fact, the courts kind of clarified that landlords need to do their homework before beginning eviction cases. So it's very important to point out that this extension to the moratorium doesn't cover holdover cases. Holdover cases are pretty much every other kind of eviction case that's not a non-payment. So for example, if the landlord says that a tenant is being a nuisance in the apartment and creating disturbance, or if the lease runs out in an apartment that's not a rent stabilized apartment, those are examples of holdover cases if legal proceedings start. Next slide. So the court did help tenants and practitioners out a little bit by providing some guidance on what needs to happen when the first moratorium runs out. So on May 22nd, they said that starting on June 20th, any petitioner, that's a landlord, seeking to commence a summary proceeding for non-payment of rent will file, along with that petition, an affidavit by a person with knowledge of the facts stating the proposed respondent or respondents is not someone eligible for unemployment or benefits or otherwise facing financial hardship due to COVID. So this means that the landlord or their agents is supposed to find out whether someone is covered before starting a case. Whether that actually will happen or not, and whether they'll try to find that information out before starting a case is still, it's still a question. If you feel that you fall into the protected categories, you should definitely try to speak to an attorney, contact Brooklyn A about responding to a non-payment petition after June 20th. Next slide. And the court gave some more guidance. They said that that same type of affidavit that we just talked about needs to be filed to try to get a default judgment against tenants in a non-payment, when they don't appear, or before trying to enforce a warrant of eviction that was awarded in non-payment cases before March 20th, before the moratorium started. So there's still some protection for people who had cases from before, or tenants that default because they didn't, they don't show up to court. And I believe that is the end of the moratorium section.
Yes, and so I would like to introduce Alejandro, who is going to be talking about forming tenant associations.
Thanks so much, Christy. Hi, everyone. My name is Alejandro Vera. I work with the Group Representation Unit as a staff attorney. More recently, I've been helping clients who have come to BKA to help organize their tenant association. And I want to start off my portion of the presentation with a survey. Sarah, Sarah has a poll for us to take. I'd like to just get a snapshot of how many folks on this call are currently involved in a tenant association. You can just take a minute to answer that. And I guess, Sarah, you'll let me know. I can't see the poll, but Sarah will let me know.
I will let you know the results when
Great.
as they come in. Yep.
All right, the suspense. So we'll get back to that. We can move on to the next screen until we get those results. Why do you even want to have a tenant association? Well, it serves as a good soundboard for existing and future tenant issues. It's not to say that you need to become best friends with your neighbors. Perhaps you're a person of privacy. You want to live alone. You want to deal with anybody. That makes a whole lot of sense. But what makes even more sense is understanding the issues that are affecting your building and individual units, because you're likely facing the same thing. A tenant association allows you to organize information that you wouldn't otherwise have access to, and then make certain requests and, if necessary, demands of a landlord that relate to the habitability of a building. And how do you form a tenant association? It is so easy. You don't need to file any papers unless you want to get really specific about the type of tenant association you form. But in our practice at BKA, it's actually a loose organization of tenants. They assert themselves and inform the landlord that they're forming a tenant association. And that's about as formal as you need to get in order to have attorneys that you're seeking representation from to recognize you as a tenant association. You know, this might sound daunting, the work behind forming a tenant association, and it can be, but good news, Brooklyn A has community organizers on staff. Many of us are familiar with tenant association formation. No need to reinvent the wheel. If you think this is a good time to explore forming a tenant association or address issues in common in your building, please leave your email address in the chat or contact one of us on this conference call. We'll be happy to host a consultation with you and an intake and see what we can do for you.
Okay, are you ready for our survey results?
Only if it's good results. Yeah.
Of our attendees, 21% are currently involved in a tenants association, and 79% say they're not currently involved in a tenants association.
Okay. This is my unsurprised face. That number is so low. It's not surprising given people's tendency for privacy. However, perhaps even more so because of COVID, you want to explore, not pursue, but at least explore the worth and value of having a tenant association. And if you weren't in COVID, it would still be helpful, especially if you're thinking about putting roots down, or you simply care about the welfare of your neighbors or the welfare of your building and how that might be impacting your rental rates. I think we can go to the last slide for tenant associations now. Thank you so much, Christy. And one more time to reiterate, I want to focus on some of the details that tenants have when they're reluctant to form a tenant association. The main purpose behind a TA is to collectively bargain with the landlord. It's much easier to say no to one individual person than it is to say no to a group of 20, say, people who are experiencing the same issues and need resolutions to the issues they're facing in common. Also, tenant associations are voluntary associations. There shouldn't be any dues. When you're forming a tenant association, there shouldn't be any dues for new members, and no one is getting paid to do this job. It's a labor of love, but it's also a labor regarding your housing. And that's way more important too, I think. Lastly, to wrap up my section of the presentation, it's perfectly legal to form a TA in your building without fear of reprisal or pushback or any kind of consequence from a landlord. To boot, a building owner is also obligated to allow you to use meeting spaces, public spaces in the building to process and have your meetings. There's a lot of law on the side of tenants to simply organize speech and organize actions that are legitimate. Lastly, I just want to say one more time because it bears repeating. If you're interested in forming a TA, if you believe your building or you as an individual might benefit from starting the conversation in your building, please leave us a line, leave us your email. We want to help you stand this up. No need to reinvent the wheel and do all that hard work first and then get frustrated with the process. There are easy channels to get this done, and at least explore your options. Thank you.
Thank you, Alejandro. I'm going to turn it over to Jonathan now, who is going to talk about your rights if you're facing retaliation, harassment, or discrimination by your landlord.
Good evening, everyone. My name is Jonathan, and I will be talking to you about harassment and retaliation. First, we have a slide that shows that it is illegal for landlords in New York to retaliate against tenants who make a good faith complaint to their landlord or to a government agency. All tenants are protected from this kind of retaliation by law. Under New York State's rent regulation laws, harassment is defined as conduct by a landlord that directly or indirectly interferes with or is intended to interfere with your privacy, comfort, and enjoyment of your dwelling. And these are examples of harassment. Actions that constitute harassment include using force and threatening to use force against a tenant, destroying a tenant's property, knowingly providing false or misleading information about whether a unit is rent stabilized or rent controlled, discontinuing essential services such as heat or hot water, failing or delaying to correct hazardous conditions, including mold, lead paint, dust, and debris. Commencing baseless court proceedings against a tenant. Falsely certifying that a hazardous condition has been corrected. Changing the locks to a tenant's front door without giving the tenant a new key. Could be eviction or an illegal lockout as well. But these are all actions that constitute harassment. Examples of retaliation from a landlord. Within 1 year of a tenant's complaint, the landlord substantially alters the terms of the tenant's rental agreement, or the landlord refuses to continue to rent to you, or fails to renew a lease after your lease has expired. Maybe they're offering you a new lease with unreasonable rent increase, or your landlord brings an eviction case against you within 1 year of making a complaint. These are all examples of retaliation. I would like to give some clear illustrations in 3 different scenarios, which could either demonstrate harassment, retaliation, or both. Ralph repeatedly complains to his landlord about mold and a leaking ceiling in his apartment. His landlord comes to the apartment on 4 different occasions to make repairs, but does not address or fix the ceiling or remediate mold. The landlord tells Ralph to find a new place to live when he visited the apartment. He's not fixing anything. This is an example of harassment. Could also be retaliation, but it's definitely an example of harassment. Susan has complained to her landlord. The landlord wants Susan to move, so he deliberately failed to provide adequate heat in the apartment, hoping Susan would move out. This is an example of harassment. It's also an example of retaliation. Jim rents an apartment and complains about exposed wires in his apartment. The landlord seeks to raise Jim's rent, $500, to pay for repairs. This is definitely retaliation. Consequences of finding harassment against a landlord. If the judge determines that your landlord has engaged in harassment, the first offense is a fine of $1,000 to $10,000. The second offense within 5 years of the first fine starts at $2,000. Now I want to talk about housing discrimination in New York, the COVID-19 edition. Under New York State human rights law, it is unlawful to discriminate against persons based on age, citizenship status, color, creed, disability, family status, gender, lawful occupation, lawful source of income, marital status, national origin, partnership status, race, sexual orientation, veteran or military active duty status, status as a victim of domestic violence. Discrimination is defined as differential treatment based on a protected characteristic. Differential treatment may be in renting and selling of housing, the conditions and treatment of a place where you already live, or in advertising of a place to rent. The protected characteristics have been mentioned in the first slide. I would like to also show some examples in the next slide. Examples of housing discrimination. The first example, a Latino tenant is refused repairs in his apartment while white tenants receive repairs. This is an example of racial discrimination. A landlord does not recognize succession rights of Polish-speaking people, families, while succession rights of English speakers are honored. This is an example of discrimination based on nationality. Heat and hot water are inconsistent in apartments rented by Latinos. White tenants are not affected by non-functioning heat because they have a separate boiler or heating system. This is an example of racial discrimination. A Section 8 voucher holder applies for an apartment in a 5-family unit and is denied because the owner won't accept vouchers. This is an example of lawful source of income discrimination. Next slide, please. Here we define disability. The New York State human rights law defines disability as a physical or mental impairment that substantially limits major life activities. This includes former addictions, alcoholism or drug addiction, mental illness, orthopedic, visual, speech, and hearing impairments. The impairment of a major life activity of central importance to daily life, such as seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, and speaking. These are all examples of a disability. And under the New York human rights law, COVID-19 is considered a disability. So owners of property must make reasonable accommodations even to policies that were instituted to combat COVID-19 pandemic. Also, an example would be medical personnel and caretakers must be allowed in your home, even if there is a general restriction on visitors. Reasonable accommodations entail changes to a building policy to make an apartment equally enjoyable and livable to someone with a disability. Relaxing a pet policy for someone who needs an animal for emotional support needs. Moving someone who lacks mobility to the front of the wait list for an apartment on the first floor. These are all examples of reasonable accommodations that have to be made for persons with disabilities. If you experience discrimination, retaliation, or harassment, contact us at info@bka.org or call us at 718-487-2300. You can also contact the New York City Commission on Human Rights and file a complaint with the New York City Commission of Human Rights by calling 311 or calling 212-416-0197. You can also contact the New York State Division on Human Rights. You can email a complaint form to complaints@dhr.ny.gov or fax it to 718-741-8322. The next slide is for frequently asked questions, and we can also get your...
Sorry, Jonathan. Yeah, so anyone who would like, what's it called, a fact sheet, we actually created two for two different units in our organization. We may be providing other subjects if you're interested. If you want a copy of this, just put your email in the chat box and we'll send it out after this meeting. Thanks, Sarah.
Thanks, Christy, and thanks so much to all of the presenters. This was so informative, and we have lots of questions, so let's get started with them. So the first question we have, this person asks, my lease recently expired on April 23rd, and I have not signed another lease. I did pay my rent on May 1st, and I'd like to continue paying on a monthly basis. I'm reluctant to sign another lease in this climate. My building/landlord is not happy about this and insists that I need to sign another lease or let them know if I intend to vacate. Do I need to sign another lease? Is there a law that would require me under a 12-month lease or similar? Do I live in a rent-stabilized building? I do live in a rent-stabilized building, but I am a tenant that pays market rates. I did not receive an apartment through the lottery, and I can provide more information. Also, are they allowed to enter my apartment without permission? I'm currently out of state, and my neighbor told me they were knocking on my door yesterday, but she intervened and told them I was away, but she would contact me. Who would like to take that question?
I can talk about this one.
Great, thanks, Sam.
So the question of whether you're required to sign a lease or not, it hinges on whether you are a rent stabilized tenant or not. From the information that you gave us, it sounds like you live in an apartment that's part of a building that has both rent stabilized units and market rate units. And it sounds like you're saying that you live in a market rate unit, and that you're not covered, and that you're not living in a rent stabilized apartment. But, you might want to, just double check that you're not covered by the rent stabilization law by trying to make a request to DHCR to get a rent history, and try to find out if there's any chance they might be covered. If you aren't living in a rent stabilized apartment, then no, there's no legal right that the landlord gets to, have you sign a lease. If you are under a lease and you end up not signing it in a market rate apartment, then you just switch to being a month-to-month tenant for each month that the landlord will accept rent from you. And then if the landlord wants to end that month-to-month tenancy, they need to send you a notice. And if you've been living in the apartment for more than a year, it needs to be 60 days notice that your tenancy, is going to be terminated by the landlord. On the other hand, if you do find out that you live in a rent stabilized apartment, that you fall under that category, then yes, the landlord does have a right to have their tenants in those units either sign the lease or vacate the apartment. It can be a ground for a holdover eviction if a tenant in a rent stabilized unit doesn't sign the lease. Currently, those kinds of new cases can't be filed, but when cases can be filed, they could start a holdover if they terminate your tenancy first. And I believe there was another part to the question.
The last part of the question was, is the landlord allowed to enter their apartment without them being there, or even if they're there?
So unfortunately, the landlord does have a right to access apartments that they rent. They have a right to access it to make repairs and inspect, that sort of thing. Hopefully landlords are being thoughtful about getting access to people's apartments, especially when there's this health risk. But there is a requirement that they be able to get into the apartment, in case there's an issue with the maintenance. If there are special concerns that you have about the landlord not accessing your space, if there's someone that has a high health risk in your apartment, something that might be good to do would be to communicate with the landlord about that and just say, it's not good to have people in the apartment right now if it doesn't need to happen in the near future.
So I think in her situation, she's actually out of the state or out of town, and the landlord is trying to get into her apartment without permission. So under the law, the landlord has to provide at least 24-hour notice or 48-hour notice to get into your apartment. And it also has to be for emergency repairs. You can't just come into your apartment for whatever reason. It has to be an emergency, and he has to provide you notice. So I would reach out to your landlord and find out what's going on. Hopefully there's not a gas leak or a leak in your apartment, and that's why he's trying to get into your apartment. So I would reach out to your landlord and find out what's going on.
Thanks so much, Kirsty and Sam. We have a question from Grace. If our landlord has shut off hot water and cooking gas and attempted an illegal lockout, do we still have protections if we do not have a written lease and we are participating in a rent strike? If we file an HP action against our landlord for harassment, will we face retaliation for non-payment for unpaid rent?
I can take this question.
I would
Hi,
like to
Grace.
answer
I'm
this.
sorry to hear that this is happening. And you still do have rights if there is a shut off of hot water or cooking gas, especially during the pandemic. Housing court is open to hear these types of cases. These are what are considered emergency cases. Without fully understanding your case, though, I'm hesitant to give any kind of legal advice or opinion right now. But let me try to continue with it. We have protections. We do not have a written lease. I don't think that would bar keeping gas on, especially if folks are living there and paying rent anyway. And you're participating in a rent strike. So I kind of couch, or I'd section off that issue about rent strikes. There may or may not be grounds for a legitimate rent strike. Usually rent strikes are paired with existing conditions in the building that prevent or that void what everybody is entitled to, which is called a warranty of habitability in the building. So without understanding the details of what's going on in your building, I can't say how that rent strike factors into it. And then your last question is, if we file an HP action against our landlord for harassment, will we face retaliation for non-payment for unpaid rent? You shouldn't face any retaliation for filing an HP action, especially during COVID, but I think the best advice that I can give you right now is to please leave your email. One of the attorneys on this call will return your call, likely within the next business day, to get more information, simply because what you provided us, although it's good, isn't complete. So we'd be remiss to advise you here and then have somebody else on the call who's facing a similar situation believe that this advice also applies to them. I hope I answered part of your question, though.
Thanks, Alejandro. Before we get to more questions in the chat, Cesar Vargas has had their hand up for a long time, so I want to allow them to speak. Cesar?
Hi there. I'm so sorry. It was by accident that I raised my hand, but I've listened to great information.
Okay, great. Thanks for joining us.
Sarah, there was a question like further up, which was a basic question on what an HP is. An HP is an action that you start for housing preservation, basically saying that there's repairs or conditions in the apartment that need to be fixed. The law has changed, which allows harassment claims as well. So that's what an HP is. It's just the name of the case.
Thanks, Christy. Okay, a question. During COVID-19, NYCHA has put a hold on major repairs within tenants' apartments. What can be done to prevent these actions, as NYCHA management has been using the crisis as an excuse of not making repairs?
So I think the answer to this question depends in part on what kind of a repair it is. NYCHA is still required to do certain kinds of repairs. And I think that for us internally, a list of those repairs was circulated. And I think we should be able to find it and maybe provide it to you if you provide your email address. But I think without knowing more about what the repair is and the severity of it, I think it would be hard to answer the question about whether NYCHA would be on the hook for doing it right now.
Thanks, Sam. Yes. So,
just to add a little bit more, we actually have been filing a lot of emergency actions against NYCHA for serious repairs. So we've been doing it since March. So definitely reach out to us and we can help you with that.
Yes, and please reach out to us. I know you have our information, so we would look forward to hearing from you. Okay. And also just want to point out that in the chat, we have listed a couple of times the lookup tool to look to see if your unit and building is rent stabilized. So you can use that as a resource. Okay. We have a question here. I have never had a lease. I live in a small building, 3 units, and the landlord lives in one of those units. When this building passes on to another owner, either family member or by sale, do I have any protections? I've paid by check until 2 months ago when the landlord requested I pay in check because she cannot go to the bank.
Jonathan, you want to try and answer this?
Yes, I want to answer this. You do have some limited protections. You said you were living in a single family home. There are some exemptions when it comes to discrimination. And a single family home where the landlord actually lives in the house is an exemption and may not fall under the large list of protections that rent stabilized housing and some other housing in New York City share. So that's one thing. I mean, you can still call us and we will see what we can do regarding the details of your case to see how we can actually address the issue that what your concern is, or give you some legal advice regarding what your protections are. I mean, it would also depend on how long you were living in the premises. If you've been in the premises for over 30 days, you have to receive a notice before you can be removed from the premises. If you are a tenant in the premises, you have certain rights, and call our office will make you aware of those rights and those protections.
May I add? I guess the second part of that question said that the landlord had made a request of the tenant to pay in cash because the landlord is having difficulties going to the bank. My experience in the past has always been to always pay with either money order or with a check, because if you pay by cash, there's no proof that you paid that rent. So just to add on to that question, I always recommend that you pay either by check or by money order, preferably by postal money order, and save your receipt so that you can have proof. Just hypothetically, if the landlord decides to take you to court, saying that you did not pay them and you're saying you paid by cash, then what's your proof? So you always want to provide documentation just in case.
Just to add a little bit more on that, in regards to paying with cash, if you do pay, we of course agree that you should pay by check or money order so you have proof. But if you do pay by cash, then you must get a receipt from the landlord, and it has to be signed by the landlord and dated, and it has to state what month the rent is for, so that it's clear to both parties what is being paid. And you cannot, like, if they're asking for cash, you have to push and say, okay, if I'm giving you cash, you have to give me a receipt. without the receipt, I'm not giving you cash. And you have that right to say that. Also, there's a lot of electronic apps that everybody is using, Zelle and like Venmo, and there's other electronic methods of sending money that you can keep a record of. So that's another option. So perhaps you can have that conversation with your landlord to see if there's other options besides cash.
Thanks,
Sarah,
everyone.
I think we missed a question. I think we missed a question from Robert.
Okay.
It says, I am in a free market apartment. My landlord renewed our lease, but we never signed. Can he do a holdover at this time? Sam, do you want to take that on?
Yeah. So the question is, if you're in a free market apartment and you didn't sign the lease, sorry, just look at the question.
So the landlord renewed the lease, but the tenants never signed it. Can they technically start a holdover?
Well, I think that would depend on whether the landlord is still accepting the renewal lease, I guess. I mean, if their offer is still standing. If the landlord will still accept the renewal lease and you're still interested in living in the apartment, you can just sign and return the renewal lease and be covered for that period of time. If they're not willing to accept the renewal lease, then you'd likely be a month-to-month tenant, which wouldn't offer the same protections as being under a lease. But again, kind of like I said earlier, depending on how long you've lived in a market rate apartment, the landlord needs to give you more and more notice before terminating your tenancy. If you've been living there for over a year, you get 60 days notice. Over 2 years, you get 90 days notice.
And it's not an automatic holdover. So the landlord has a right to start a case or not start a case if he has a relationship with you. Just because your lease expired doesn't mean that a case will automatically start. I think what Sam was talking about before with rent stabilized units, you are obligated under the law to sign your renewal lease for rent stabilized units. For free market units, there's no obligation to sign a lease. It is a good thing to have a lease because you're protected under that lease, but it's not an obligation, and therefore a holdover wouldn't automatically happen. But we can provide you more information if you want to talk to one of us.
Thanks, everyone. Okay, we have a question. I've been a tenant for 10 years in the same building. Due to government mandate, I had to close my business, and I've not had any income since March 16th. I cannot afford current rent anymore. What can I do? My landlord wants me to pay the full rent and I cannot afford it anymore. I applied for the business loan and I'm not eligible for unemployment insurance. Looks like Alejandro wants to take this.
I'll try. I'm sorry that you're going through this. So can't afford to pay your rent anymore. You've been impacted by COVID, obviously, but for whatever reason that we won't get into here, you're ineligible for unemployment insurance. They want you to pay full rent. If you're able to, the general advice that I can give right now is that if you're able to pay some portion of your rent without significantly impacting your ability to live during this pandemic, then try to pay something. But if it's completely impossible to pay anything at all, because you have a finite income or even a fixed income, then let's get on the phone with each other. Let's talk about the details of the case so I can understand more about the business that you had, why you're not qualifying for a business loan, and the reason why you're ineligible for employment insurance. There might be other forms of relief that you can get that we don't know yet, but we'd know it if we were able to get a sense of your demographics, your income level, and other pieces of information that you obviously, and you should not, don't share on this chat. But please do leave your contact information. You can message one of us privately if you don't want to share that with the general group.
And just to add on to that, you're not alone. There are so many people who are in the same situation as you, and that is why the city and the state is trying different things to assist tenants in paying their rent going forward. There's ideas talking about rent vouchers. There's different programs that are coming forward that may be able to assist people in the future. So you're not alone. And I know that the landlord is going to be trying to harass you and trying to push you. You just have to explain, hey, we're in a pandemic. It's not my fault that my business closed. We're all in this together. I need you to be a bit more understanding. And I think if you have a human conversation with them, hopefully they'll be a bit more reasonable. But like to try to scare you into paying something is too much. Pay what you can, but just be open and honest and explain what's happening. And that's the best solution.
I think if I can add on to something that Christy said, there's something that I didn't include when I was talking about the eviction moratorium early in the presentation, and I meant to. So it might be important to note that just yesterday, actually, the New York State Legislature passed a bill that would extend that eviction moratorium longer. So this bill that's currently on its way to Governor Cuomo for him to choose whether to sign or not, it's not law yet, but it was passed by the Senate. What it would do is that it would say that anyone that's been financially affected by COVID or is eligible for unemployment insurance from the date of March 7th until the time that New York State is fully reopened, there would be an eviction moratorium that covers those people and prevents them from being evicted. So again, this isn't law yet. This is something that's basically on Governor Cuomo's desk. This is very fresh news, but it's just something for folks to be aware of, so that that August 20th might not be the cliff at which everybody can get evicted, and then the New York legislature is working on it.
Thanks, Sam. I have another question for you, so hang on a second. But before I ask you that question, I also want to mention that we at Brooklyn A have a small business support project as well, where we are helping small business owners to find relief, to negotiate with their landlords, and during this time period. So you can also reach out to us to receive services through our small business support project that might be able to help out in your situation. So just, you can leave your email address and we'll be in contact. Sam, back to what you were just saying, if the moratorium is extended even further, should I be paying my rent in the meantime?
So if you have the ability to pay rent, it would be a good idea to pay rent, to show that you have the ability to pay rent going forward. Obviously, everyone's situation is different. If you have been affected and your income is much lower than it used to be and you can't pay all of the rent, kind of like the conversation we were having before on a previous question, you have to take that into account. But if you can pay rent, you're under a lease already, or if you have an ongoing relationship with the landlord, you want to keep living there, then yes, you should be paying rent, because that will keep you in that apartment, and it also could help you to avoid problems later, because if you don't pay rent now, and maybe you have the ability to now, there's always the chance that something could happen in the future where some of that money needs to get used up, and then all of a sudden you can't pay back the rent that you avoided paying earlier. So of course it's impossible to predict the future about what will happen to each person and what the New York State lawmakers will decide to do. But yeah, in a general sense, it would be good to pay rent if you can afford to. Of course, unless you're already going on a rent strike with your building, as Alejandro described, you're going on a rent strike for conditions in your building, you're banded together with the TA.
Thanks, Sam. So we have a question. How do you prove that you were affected by COVID? What are some examples of things that you can do to prove that? Could you get a note from your employer? What else could you do? Alejandro, do you want to take that?
Sure, yeah. So this is going to vary case by case. Some of the more general forms of proof that we've been seeing with our clients have been have you applied for unemployment insurance since the onset of COVID, which was early March, mid-March? That's one proof. If you work in the gig economy, if you drive for Uber, if you do any other kind of freelance work for yourself, can you prove that any upcoming contracts or promises of work that you were going to accomplish between then and now have been sabotaged, have been canceled because of COVID? That's a form of proof as well. Do you have a note, as Sarah mentioned, and as the asker of the question posed in the chat? Do you have any kind of written proof from your employer if you work in a salary job or an hourly job that demonstrates reduced income? All those pieces of information are grist for the mill that later set you up to demonstrate that, yes, you are in fact being impacted by COVID. No, this is not a time that you're using to be opportunistic and get cheaper rent because you just don't feel like paying it. There are standards out there. If you don't know if you have proof, we can help you figure that out as well based on the questions we'd ask you in your intake process.
Thanks so much, Alejandro. Is there anything else that any of the other panelists want to add to that? Okay. Great. Well, those are the end of our questions in the chat. Feel free to, we'll stay on for a couple of minutes. If you have any more questions, feel free to write them in the chat. You can also raise your hands. Thank you to Lyric for providing our information in the chat, as well as some of the lookup tools and resources. We appreciate your help.
I'd like to say thank you to Brooklyn Legal Services, for this virtual town hall. Is much needed. You provide a lot of information. Also like to thank Assembly Member Radiz Bashad and Council Member Alika Ampry-Samuel for also being a sponsor. I look forward to your future events. There's so much to talk about: succession rights, J51 tax credits. I think a lot of our tenants need to know how those affect their living situation, what their tenants' rights are, especially as it relates to MCI increases or proposed MCI increases. I definitely look forward to partnering with you, and thank you very much.
Thanks so much for joining us. We really appreciate it and can look forward to continuing to work together.
Thank you.
Not seeing any additional questions for right now. I think we'll wrap up. Once again, if you have any questions that come up for you over the next couple of hours, days, weeks, months, feel free to reach out to us about housing questions or about any of our other services. As I mentioned in the beginning, we also offer services around foreclosure prevention, small business support project around tax assistance, and we would be happy to answer your questions. We thank everyone for attending, for taking the time tonight to be here. Know that Brooklyn A is here for you during this really challenging and uncertain time period, and we'll get through it together. So have a good night, everyone, and thanks to all of our panelists.
Sarah, bye everyone.
Good night, guys.